Hi everyone and welcome to the Data Factory series. And today we have the interesting topic of Demystifying Cloud Act. My name is Ebba Josefsson Lindqvist and I'm project manager for the Data Factory here at AI Sweden.
And my name is Josefin Remsgård. I work as a legal coordinator here at AI Sweden.
And just a few words about the Data Factory. So the Data Factory at AI Sweden is the infrastructure, the tool chains, the legal frameworks, data sets, and everything that our partners and the projects would need to conduct AI testing, model training, and research. And it's also makes available compute and storage for our partners for their AI projects, as well as know-how on how to manage these data factory solutions and how to set them up, etc. And we just recently upgraded what we have as the infrastructure, and we now have the new state-of-the-art DGX A100 that we offer to our partners to use and also for the projects. So if you're interested in knowing more about that, you're welcome just to reach out to any of us, but maybe me as the project manager would be a good way in. And Josefin, we both have legal background. Yes. Or background in law.
Yeah, we do. And we are currently working with creating the legal structure for the data factory, which is very interesting. That entails, for example, agreements for accessing the data factory and also receiving data sets and sharing data sets and a lot of different legal questions. And we are also working with creating a legal expert group together with our partners. So we will have legal experts from our partners working together on specific questions, legal questions concerning AI, for example, IPR, GDPR, and different types of questions concerning that. So that will be very interesting. And today is the first time that the Data Factory series are touching upon some legal perspectives when it comes to AI. So that is also exciting.
Yes, it's really fun actually to do a little bit of this legal touch, but that's not the only perspective we're going to have on Cloud Act today. We'll also have a bit of a practical perspective. So we're really happy to have our guests with us today. First, we have Ted Schönbeck, who is Head of Cloud Technology at Google Cloud Sweden. We also have Mikael Granberg from MAQS law firm, who is a lawyer and also legal director of digital business at MAQS. And then, of course, we also have Evelina Antila, who is general counsel and AI ethics at Peltarion. And you are all from partner organizations of AI Sweden. And Mikael and Evelina, we will welcome you back again for a panel discussion about 1:30. And before that, we will have Ted do a presentation about Cloud Act. So welcome, Ted. Very nice to have you here today. And before you start, actually, I will just say the webinar is being recorded, and you in the audience, please feel free to type in questions in the Q&A tab, and Josefin will help us monitor the questions that come in, and we will bring them up at the panel discussion after Ted's presentation.
Yes.
So thank you. See you soon.
Hey.
Okay, welcome, Ted.
Yeah, thank you. So yeah, my name is Ted Schönbeck, and as said, I'm the head of cloud technology for Google in Sweden. And let me share my desktop here so I can show you the presentation that I want to share with you today. Can you see the picture?
We can see it perfectly well. Thank you.
Right. So before we get started, I just want to take a minute, a little bit setting the scene here. So first of all, I'm not a lawyer, so this will not be a detailed, run through of Cloud Act from a legal perspective. But what I have been doing is that I've read through the entire Cloud Act. I've probably read the 30 or 40 analyst reports on Cloud Act and its implications. But most importantly, I probably had 100 meetings with customers, partners, communities, and lawmakers on Cloud Act to really get the feel for what Cloud Act really is all about, both from what people fear it is, but also from what it actually is in actual use. So in this session, what I really want to do is help you all kind of move beyond the myth, because there is a massive myth surrounding Cloud Act, to give you a better feeling for what Cloud Act actually is. But I also want to move a little bit away from Cloud Act as such, and I want to challenge you a little bit to start thinking about the notion of risk, the risk of data ending up somewhere where you don't want it to end up, because that at the end of the day is what this is all about. And it's important to be able to make a full risk adjustment and an analysis, and not just base it on Cloud Act, because then we are kind of fooling ourselves. And to be able to do that, before I will deep dive into Cloud Act's practical implications, I just want to set this scene a little bit, talk about security in the cloud, because that is an important part to be able to do that security adjustment. I'm going to talk about how we at Google do security, but and it is a key differentiator for us, but for simple sake, you could say that this is similar to how all the big, large US cloud providers do security. But let's back off for a second and think about, how do you do data security on-prem? Well, the way most organizations do security on-prem is that you build fences, walls, and moats. You build castles to keep the bad guys out, because that's how the technology to do security on-prem works. The problem with this approach is that sometimes it ends up a little bit more like this, because once you're inside that hard outer shell, everything is pretty soft and gooey. There's really nothing protecting you. And if you look at a lot of the hacker attacks that have taken place in recent times, it actually shows that the hackers were inside for weeks or months before being detected, if even being detected at all, to be honest. So how do Google do security? You can just imagine the number of attacks Google are under constantly. Well, our approach to security is as simple as it is sophisticated. We trust nothing. Question is, how do you implement a trust nothing methodology in an open, fluffy, wonderful public cloud? Well, the way we've done it is that we completely reimagined the security model from the ground up. So we're not just relying on these outer defenses. Instead, we decentralize security into each and every component of our platform. We call this layered defense at depth. And everything in our platform is always encrypted by default. You cannot turn this off. Every data point is encrypted when it's resting on a hard drive, when it's being transit between different places, but also while it's being processed in the processor of a computer by default. To support this model, Google has more than 1,000 security engineers, some of the smartest people on the planet, a lot of them ex-hackers who turn to the good side. And apart from developing our security model, they publish a lot of white papers on how to do security, and they also detect a lot of security vulnerabilities that we fix and share with other vendors. And roughly, on an average year, 20% of all security vulnerabilities found on globally are found by Google engineers. And I think it's very difficult for any local organization, be it a Swedish company, be it a Swedish municipality, to have that level of security and capacity. And especially with legacy IT environments, to rebuild that, to have this kind of security level is simply impossible. So that's the IT security. Well, what about integrity of your data? And I think this is specifically important to point out for Google, because you need to understand that there's a massive difference between Google consumer services and Google enterprise services, which is the services we offer to organizations. And first of all, just to make it very clear, data that customers put in our systems is theirs, always. We do not scan that for adverts. We don't sell it to third parties. It's not even stored in the same platform as our Google consumer services. We will never process it unless you ask us to as part of a service you're requesting. You decide where the data ends up. If you want it to be stored in Hamina in Finland, which is the closest data center to Sweden, it will never leave Hamina in Finland. We are open to third-party audits as part of being GDPR compliant. And as said, data is always encrypted by default, either using our keys or you can bring your own keys. And if you want to, you can even store those keys outside of Google, which makes it impossible for us to read the data because you have the keys. And actually, there are a lot of analyst reports out there kind of describing this difference between the on-prem world and the cloud world when it comes to security. And as it happens, in September of this year, Tech World, the Swedish magazine, published an extensive article referring to a report that had been done analyzing the difference. And it kind of confirms what I'm trying to explain here, that the likeliness of data leaking from a large cloud provider is about half as big as it is compared to a local data center, based on the facts that I've just described to you. And also, once inside, it's a lot easier to move on, to find and keep, hurting your system, stealing more data compared to cloud. So just setting the scene to understand, just having this gut feeling of how secure your data is in cloud versus in your own on-prem world. But now let's move over to Google Cloud, to Cloud Act. So the first thing I want to point out, I've been working with IT in over 20 years, and I can honestly say I've never experienced the level of confusion and misunderstanding that we're seeing around Cloud Act. And unfortunately, to be very, very transparent and honest, a lot of that confusion is related to miscommunication on purpose by individuals and organizations who wants to create a fear of Cloud Act to be able to compete with Microsoft, Amazon, Google, and others. And that's probably the saddest part of all this. So what does people actually think Cloud Act is, and what kind of effect does it have? Well, simply put, I've asked a lot of customers, and their obvious immediate answer is that, well, with Cloud Act, US authorities automatically get access to data stored in large cloud providers. And if you Google Cloud Act, you will find a lot of web pages with local organizations who claim this, who state this on their web pages. If you use a US cloud provider, data will automatically be available to US authorities. Now, this is, of course, absurd to me. But that's why this is so interesting to talk about, this massive misunderstanding. So, and before moving into what Cloud actually is, was Cloud Act created? The thing is that over the last 15, 20 years, we've seen a massive digitalization and a massive globalization of digitalization. It's really, really difficult today for crime-fighting authorities, and please remember, crime-fighting authorities, because that's what we're talking about here, to go about doing their job in a global digital economy where laws just aren't built for globalization. And this is being exploited by organized crime, by terrorism, and creates massive challenges for crime-fighting authorities. And because of this, right now, in the European Union, there's a huge work going on around something called the e-evidence initiative, which really is a way of creating clarity for crime-fighting authorities in Europe to go about doing their job without messing up GDPR. But the problem is that the European Union is a lot of countries that need to agree, so it takes time. Cloud Act is just the United States being a few years ahead of us. So 10 minutes into the presentation, what is Cloud Act? Well, first of all, and you would be surprised, 9 out of 10 people I talk to about this are not aware about the basic thing, that Cloud Act is actually an abbreviation, where CLOUD stands for Clarifying Lawful Overseas Use of Data. It's actually a bit unfortunate that the abbreviation becomes CLOUD, though probably on purpose, because it's not just for cloud providers. Any company doing business on US soil is under Cloud Act. A lot of Swedish companies have offices on US soil, and as such, they are under Cloud Act jurisdiction. So what is Cloud Act then? Well, simply put, it's a very, very detailed legal framework that stipulates, and now it's a bit complicated, so listen carefully, it stipulates how US crime-fighting authorities should go about doing their job when they are investigating a crime that happened on US soil under US jurisdiction. And as part of that investigation, they believe getting access to data stored by an organization who has business on US soil, but storing that data outside of the United States. How should they go about getting access to that data to solve the crime that happened on the US jurisdiction? That's what Cloud Act is all about. But probably the easiest way to explain this is to explain it in a scenario. So On this slide, I'm going to run through a scenario of how Cloud Act would be used in practice. And please bear with me. This is a few hundred pages of law text distilled into one slide. So there are simplifications here. Everything is true, but there are some simplifications to make it easier for you to understand. So the first thing that needs to happen is there has to be a crime under US jurisdiction on US soil. This crime is investigated by a US crime fighting authority. Let's call them FBI. So the first thing FBI would have to do is to request a committee analysis where they would have to have a suspicion of a serious crime or terrorism, where they would have to present, the plausible cause, facts and evidence for this crime, including the rationale for the request. So if you get this data, how would that progress your investigation? And last, but probably the most important part, they need to pinpoint a person, an account, or a device. So a very narrow scope. They cannot say, give me all the data of organization X. They need to pinpoint a person, an account, or a device. Now, committee analysis can end in one of two ways. Either it ends with, no, you don't have enough evidence. No, the rationale is not clear. The scope is too wide. You need to narrow your scope. Or it ends with what is commonly referred to as a cloud warrant. That's a clarifying lawful oversee use of data warrant. They would then take that warrant and go to the provider of this service where the data is stored. The first thing this vendor, like Google, would do once we get a cloud warrant from FBI is to direct them to the customer. This is stipulated in Cloud Act, the right to do this. So we will tell FBI, please go and talk to customer X or organization X. They would go to your organization and say, we believe as part of a serious crime that you have data that would progress our investigation. Now it's up to you to say yes or no. Let's say you say no, they would then move back to us and say, give us the data. The first thing we would do then is go to court. This is stipulated in Cloud Act. It's called the right to quash. And we will always do this. And then we will go to court. And in this court, well, first of all, I often get the question, why is that court in the United States and not in Sweden? Well, because the crime happened in the United States. That's part of the legal global framework. If I do a crime in Brazil, it would be pretty strange if I would go to court in Norway. So that's why the court sits in the United States. In this court, FBI would have to bring up all the stuff from point one, all the evidence, everything the rational, but also stipulated by Cloud Act, the court would also take into account if revealing the data in any way would violate local law. Now, this court result could be one of two. Either it's no, you don't have enough evidence, no, this would violate GDPR or whatever, go back to the drawing board. Or it could end up with a situation where, yes, you need to hand out the data. At this point, I think it's just interesting to reflect where we are at this point. So obviously, there's a serious crime going on that in two separate legal instances, it has been validated that it is a serious crime. Giving out the data is not violating any local law. So from my end is, where is the problem at this stage? Giving out the data. But let's say still you don't want to hand out that data due to regulatory, due to whatever reason. Well, then the third level kicks in, which is commonly referred to as the airbag. Because as part of any cloud infrastructure, you could use encryption and encrypt all of your data. And you could use your own encryption keys to do this, which would make it impossible for Google or any cloud vendor, first of all, to find this person's account or this person's data. And even if we could, the data we would give to the crime fighting authority is encrypted, so they would not be able to read it. Now, as part of this process, you need to think about how likely is it that data stored with US cloud provider, your data, being, first of all, ending up in a crime investigation in the United States related to a crime that happened on the US soil. And after that, running through this entire process that I just described, at the end of that process, data would actually be handed out in a way that it would be able to be read by a foreign authority. My analysis of this is that it's extremely unlikely. Unfortunately, another organization in Sweden came to a different conclusion, that it was likely. And I leave that up to you really to decide, okay? But a very important thing here when kind of comparing how secure and safe is your data is, what if you store your data in your own data center or with a local service provider? That means your data is safe, right? Probably not. First of all, maybe your platform is not as secure as the cloud platform. But more importantly, if a US crime-fighting authority is investigating a crime where data being stored by a Swedish organization on Swedish soil and not on the Cloud Act, there's another legal framework kicking in called MLATS, or Mutual Legal Assistance Treaty, signed by the European Union and the United States in 2003. It is kind of like Cloud Act, but not nearly as clear, not nearly as well stipulated, both regarding rights for the crime-fighting authority and the individual and the organization. But MLATs are used daily almost to get data, so you could still be enforced by Swedish police to give out data to a US crime-fighting authority, but using MLATs instead of Cloud Act. So at this point, you need to think about the total risk for your data. Where is your data the most secure? From Cloud Act, from MLATs, from hackers? That making that full assumption and analysis of the situation, because at the end of the day, that is what really, really matters. And to summarize, Cloud Act does not give US authorities automatic access to data stored in any US cloud provider. Cloud Act is a legal framework creating clarity and predictability while protecting user data. That is why US cloud providers are positive towards Cloud Act, because Cloud Act creates clarity. It creates rights for us, rights for individuals, rights for crime-fighting authorities. It's like having rules to play a game versus not having rules to play a game. And non-US based organizations are under similar but less predictable, less defined legal frameworks called MLATs. In my view, for storing data, there are very, very few places where data is more safe and more secure than with a large US cloud provider. So that was kind of the overall explanation of how kind of Cloud Act works in real life. But before moving on to the panel, I just want to give you a few separate views on this subject that you can just Google this and you will find a lot of different views. But I just want to run you through from Swedish law firms and security experts. Now, some of these are in Swedish, but I will try to translate them. The first one is from Sync Advokatbyrå. So they read through the entire Cloud Act, matched it towards Swedish laws and regulations to understand the implications of it. And their analysis is pretty clear. In their view, Cloud Act does not make it more probable that data gets released. Instead, Cloud Act establishes a transparent and clarity around the processes that makes it easier and more, predictable for everyone involved. And their final analysis in the summary of this report, and the links will be at the end of the presentation, is that in their world, it is justified, both from a practical but also from a legal perspective, for Swedish authorities and other organizations, of course, to use cloud services in their daily activities. Another view, which is specifically around ESAM that you might have heard of. Now, ESAM made a careful analysis, and in their view, they came up to the conclusion where they kind of go against my conclusion. And I respect that, it's up to everyone to have their own conclusion because this is not clear. Their conclusion is that what I showed you, these 3 different steps, in their world, that is likely to end up in a situation where data leaks. And Baker McKenzie comes to the same conclusion as I do, where they believe that for data to be revealed, you have to assume that the data has been released to a foreign authority. And the conclusion that Baker McKenzie is that the answer to that question, if you store data with a US cloud provider, you cannot assume that data has been revealed. That is completely wrong to have that assumption based on everything that I just explained to you. That it's rather very, very unlikely, and as such, you do not have to assume this. And the last part is more kind of the broader data security discussion that I think is just important to to compare with. And this is made by Aktuell Säkerhet. This is an article written in Aktuell Säkerhet by Robert Wihlborg, where his view is that kind of this fear of kind of Big Brother United States coming to read your data takes away the focus from, you know, your own security and your own processes within your own organization. And as such, everyone is looking at Cloud Act as this ghost that will create problems for everyone. If you look at some of the biggest security breaches we've had in Sweden in recent years, Transportstyrelsen, 1177, the Twitter hack that we had at Swedish television a few weeks ago, all of these, they had nothing to do with Cloud Act. They had nothing to do with US cloud providers. They had everything to do with bad processes and bad training of people. And that's the by far biggest problem for data security. And actually, a lot of those problems, take 1177 as an example. The big problem here was that, first of all, data was stored on an open, completely open web server. Well, in cloud, you would automatically get pings, recommendations every week. You have an open web server, you have an open web server, because the tools are automated. The second thing, data was stored openly, it wasn't encrypted. Well, in Google Cloud, data is always encrypted. So 1177, as an example, could not have happened if you stored your data with Google Cloud as an example, because the data is always encrypted and you can't turn it off. And I think you need to have that broader view of Cloud Act versus security issues versus MLAT, and making a total risk analysis before getting into making decisions on this. So that was it from me. I hope that was valuable, and hopefully it inspires you to think slightly differently about Cloud Act.
That's great, Ted. Thank you so much for sharing this presentation with us. And this subject has actually been requested by some of our partners because it is a hot topic to still discuss. And we have already 2 questions coming in the Q&A tab, but we will wait just a little bit, but please add in more questions and we'll bring them up very soon. But I would like to welcome back both Mikael and Evelina. Hi again. Great to have you back as well. We will put the contact details for both Evelina, Mikael, and for Ted in the chat in just a short while. So if you need to reach out to them after the webinar, you're welcome to. So if we start with you, Mikael, if you just want to give us a little bit of your background and how you come to work with Cloud Act in your daily work.
Yeah, thank you. My name is Mikael Granberg. I'm an attorney at MAQS Advokatbyrå. MAQS is a Swedish full-service law firm with close to 150 lawyers. We have offices in Stockholm, Gothenburg, Malmö, and Sundsvall. And I'm part of the digital business team within MAQS. I've been working with the tech law-related matters for a lot of years, and both in the role as an in-house counsel and also as an attorney in law firms. Within digital business, we assist companies in a variety of industries in all aspects of technology and digitalization, ranging from strategic matters to latest technological developments, such as AI, artificial intelligence, and connected devices, to all types of IT-related contracts. We are often involved in cloud-related projects, for example, where clients are in the process of moving their data to the cloud or for other reasons need assistance with issues related to digitalization, such as in relation to privacy and data protection. Yeah.
Okay, thank you so much. And so in those discussions with your clients, do you hear a lot about this concern, or do you also recognize the misconceptions that Ted bring up?
Yeah, I think a lot more organizations have become aware that, I mean, information uploaded to the cloud may be subject to a request for information under the Cloud Act and other kinds of treaties, at least since the service providers that currently dominate the market have a sufficient US connection for the Cloud Act to apply. And I think this in turn has led to an increased awareness around issues related to data security and the integrity of data. And we get a lot of questions literally on a daily basis around these subjects.
Great, thank you so much. And Evelina, great to have you here as well. Could you just give us a little bit of a background about you and Peltarion?
Yes, sure. Thank you for having me. So I'm Evelina Antila. I'm General Counsel and AI Ethics Officer at the Swedish company called Peltarion, an AI company, you can call it. So we are focusing on deep learning and have built a platform which makes it easier for companies that do not have their own AI experts or its own infrastructure to build advanced AI systems. And we are offering an end-to-end platform that lets you do everything from pre-processing of data, training models, and putting them into production. So this is not a webinar around what AI is and what you can do, but as you all know, AI needs data. Data is the fuel. And everything you can do on our platform is running on cloud. So this is, of course, a question that we've been thinking of, but I think it was interesting to hear your talk about this, Ted, because I think, in fact, I think we've never discussed Cloud Act with a customer because it's more about the general assessment that you were talking about. So the first question is, are you willing to move the data? So this is usually where we get stuck in the first place because some customers can be nervous about moving data. Might not be comfortable with cloud, and that might be because of misconceptions or that you simply have not enough knowledge about it.
So that's actually something that you experience in your work then. So you've had more of internal discussions on the subject than being like having the user perspective yourselves being users.
Yeah, exactly. And I mean, being on the cloud, that's super efficient. And so what we do is when we talk to customers that are interested in building AI systems, well, first of all, we need to find a use case. You might have a use case, and then we need to talk about the data. And the data, that could be like publicly available data, but it could be the customer's own data, which might be sensitive or not, or it could be someone else's data that you have the right to use. And then in that case, well, we typically just look case by case. What is the use case? What do you want to do? What are you afraid of? What are your position when it comes to cloud? And then, well, it might be that we move the data, or in some cases that we end the discussions there. Yeah, but I think you need to look at this like from a long-term perspective and not just the use case at hand.
Thank you very much, Evelina. So we've had Cloud Act now for about 2 years' time. And do any of you want to share some reflection really on what happened since it came into effect, and how has it affected your work, for example? Ted, would you mind starting?
You mean, sorry, I was answering a question in the chat. Maybe I should answer in live.
Yeah, I think we should answer them openly.
Okay.
That's so hold
okay.
that one.
Yeah, sorry.
Trends will be brought up later.
Okay, sorry. So what was your question? Sorry.
So yeah, I was asking, so we've had Cloud Act now for about 2 years.
Yeah.
And how has it affected your work at Google?
So yeah, I think so. Cloud Act overall has been it has been much more in focus in Sweden compared to other countries in Europe. I think part of this is that we've had a few incidents in public sector that, and you know, no one wants to be on the front of the newspapers as the person who leaked data. But also I think, you know, in Sweden we have, you know, we have so much openness in Sweden, you know, with everything from, you know, public information being available and things like that. So when it comes to these things, we are careful about it, and we really have these regulatories in place, where I think Sweden is almost ahead of every other country, or ahead or have more detail around bank secrecy and everything. So But to be honest, if I look at private companies, this has not been an issue for us. Major large Swedish organization companies, private companies use cloud services on a daily basis. So for them, there hasn't been a lot of issues. For some, regulatory heavy industries like banking, there have been discussions where they have kind of divided data into different classifications for now, where 75% of the data they are comfortable running in the cloud, whereas 25% they want to keep on-prem. But so I think the main problem so far has been in public sector. And to be honest, so far, Google hasn't, or Google Enterprise that I kind of represent, have not had a massive focus on public sector. It's been more when public sector are kind of coming to us and asking for our products and services, then we help them. But so in my day-to-day job, not a massive thing, but public sector is also quite cold when it comes to cloud services these days. So, but other than that, not a huge challenge for us in private companies.
Mikael, do you have anything that you want to share on just that topic?
Yeah, well, as I mentioned, we have seen increased awareness around matters related to data security and integrity of data. And I think as to how it has affected my work, well, I think in relation to understanding the practical implications around data security and in particular the GDPR, which may not be that uncomplicated to begin with for everyone, adding a Cloud Act dimension to this hasn't exactly helped make it easier. But I note that many clients are keen to be compliant, but they are struggling to understand what to do. So, I mean, our assistance to the clients in this respect tends to become more educational in that sense.
That's good. Thanks.
Yeah, I agree. Similar.
Okay. So we were touching on the public sector here for a little bit, because some of our audience is actually from the public sector. So is there something, we were mentioning the risk assessments, for example, and we can go a little bit deeper into that. But when it comes to the public sector, is there something that you'd want to point out specifically when it comes to the public sector, or rather inspire or encourage them to look at the cloud services, for example?
Well, I think first of all, meeting with public sector customers, there's definitely a willingness to use cloud services. And I talked to the CIO of a large Swedish healthcare region some time back, who said that he was desperate. He said that like people are dying every day in Sweden because we are not transforming our solutions for healthcare fast enough, and he feels like this. Because just to be clear, there is no legal decision made that tells you that you cannot use cloud services in public sector. There's no such thing. The only thing is that ESAM and some other organizations of public sector have given recommendations that they don't think you should. But that's not the same thing as that there is a law. And unfortunately, a lot of public organizations, there's uncertainty, you don't want to be the person getting caught, so you kind of back off and you don't do it. But there are others who I think are really bold. Some municipalities that just said, well, let's try it. Let's start using it and see what happens. So I think it goes both ways. But the interesting thing is that every public customer I talk to wants to get the power of AI and analytics and the efficiency of running things in the cloud. And they are just trying to come up with ways of doing this. So they are struggling, and I think that's positive to me, that people want to use it, but it's so much uncertainty around this that many don't dare.
Thank you, Ted.
Yeah, some clarity would be good. I mean, perhaps a new statement.
Yeah. I can ask that too.
Yeah.
You just pointed it out that there is no statement saying no, at least. So I was going to ask that too. So do we have any case law on this already, or from Europe, for example? And is there a problem that we don't have it today? Is it impeding innovation?
Yeah, I think in part that's a problem. As far as I understand, I mean, the responsibility of a cloud user of a cloud service has neither been clarified in explicit rules nor tried in court in any way of relevance to us. But I mean, we have, as Ted mentioned, some statements. One is from ESAM, where they presented their position in 2018. And I mean, of course, that's been to some extent problematic. I mean, the conclusion was not particularly detailed and it has been questioned. But I think the problem is that despite the criticism, ESAM's interpretation has been quite widely spread and accepted in the public sector, which obviously has become quite a problem. And we've also seen statements from the European Data Protection Board in relation to data, personal data, and potential conflicts with GDPR, which of course poses a problem from another perspective. So I think, yeah, clarity would be good. And on that topic, I think it should be mentioned that the government appointed an inquiry last autumn, which, among other things, were appointed to analyze the legal prerequisites for outsourcing while maintaining security for public entities. And the idea was to have this report presented in August, but the inquiry period was extended and the report is now scheduled for mid-January next year. So we'll have to wait and see.
Thank you.
Yes, and just a comment on that, the government group that was appointed were supposed to have a statement after the summer of this year, but due to many reasons, COVID and everything, this has been delayed to next year.
Yeah, so we'll have to wait for that for a little bit further then. So we do have some questions from the audience, and I wanted to bring up the first one that maybe you were trying to answer already, Ted. So someone was asking, how does Google address the Schrems 2 and what EU have communicated around Schrems 2? And just super shortly, for people who don't know what Schrems 2 is, it's a case from the European court regarding if you can use Privacy Shield, which is an agreement in between the US and Europe to transfer data from your company to the US with regard to GDPR, for example, and the regulations around transferring personal data.
So yeah, so I'm not, as said, I'm not a lawyer, and this is a very complex discussion. Simply put, Schrems is a problem for Google consumer and advertising services, but it's not the problem for Google enterprise services. So for our customers who use Google Cloud, as we call it, our services, we do not have a problem with Schrems, but Schrems is problematic for Google advertising services and Google consumer services. And actually also it's interesting to see that there was a ruling, there are a lot of rulings happening locally right now around Schrems. There was one in France last week that kind of clarified that Schrems is not the problem. And then, it takes a week, and then there was another ruling earlier this week in Germany that said, well, actually it is a problem. So it's super complicated. But I think, I talked to a lawyer about a year ago. I think he said an interesting thing. He said that kind of the laws will always be behind technology innovation, always. That's just the way it is. And we just have to push through sometimes, and then the laws change and follows through, right? It's impossible for the laws to be written ahead of technology innovation. And I think right now we are in a perfect example of where the laws are way behind innovation. And the only way to solve this is to push through and keep challenging it until we have changes in laws or clarity. We won't get clarity as long as no one is trying it and see what's going on and see what's happening. I think just as an interesting reflection, in the 2.5 years since Cloud Act was enforced, I can only speak for the Nordics, Google Cloud has not revealed data a single time, not a single time in those 2.5 years. Just to give you, and if you compare that to how many times data has been revealed in local organizations' data centers, we probably have a big difference. So yeah, maybe not answering the questions, but that question, but giving you some context.
Thank you. And I was going to ask you, Evelina, so you working for a very fast-paced startup company and being the in-house counsel, what is your reflection on the legal parts of trying to regulate the technology like this? Do you agree with Ted that law usually falls behind?
Yeah, I mean, that's always a risk, that you don't have like legislation that is fit for purpose. And I think that we are facing real challenges when it comes to regulate AI. I'm thinking about what's happening now in the EU Commission. But I mean, regulation is good, but going back to knowledge, I think it's super important about the awareness that people are actually knowing what AI is, what the Cloud Act means, what the cloud means, because then we can make decisions and actions that actually is good. So I think it comes back to that.
Yes, and so do you see, or any of you see, a change in mindset now from the people or organization that you work with or that you talk with?
Yeah, I mean, it's a big interest to start using AI, to start experiments around AI, for example. And there's, I agree that there's a great willingness to actually run it on the cloud. Yeah, I think we need clarification, because otherwise there's a risk of hampering innovation.
Thank you. And Mikael, do you see a shift in mindset in actually wanting to use, for example, cloud services? And
yeah, but I agree, and I think, as mentioned earlier, I think businesses have become more careful and also more aware of the potential implications of putting their data in the hands of someone else. I mean, not specifically related to Cloud Act issues, but rather the effects of actually entrusting someone else with your data. But I think it's also always important to keep in mind what would the alternative be, if that would be, like Ted mentioned, to have it in some kind of in-house fortress. Will that actually be a more secure option in the eventually, or will it possibly lead to even more risk instead?
good question. And then we do have also a question from the audience here. If we go back a little bit to the technology and encryption that you mentioned, Ted. So the question is, if Google Cloud Platform has to hand over data that has been encrypted with Google managed encryption keys, is Google forced to hand over the Google managed encryption keys? And if I can just add on to that question, so what's the point of being able, so when we've got all the way down to that step that you actually would have to hand over the data, why is there even a regulation about that? You can encrypt it. So I would love to hear your thoughts.
The simple answer to that is no, and that's also stipulated by Cloud Act, that we do not have to provide the encryption keys. But there are, based on regulatory situation, and also to be very transparent, I hear this from customers all the time, is that, well, we don't trust the United States anymore because of Trump, to be very honest. So people might not trust us when we say that by contract we will not turn over the encryption keys. People might feel like, well, maybe Trump can do some enforcements and force you to hand them over. So we still want to have our own encryption keys externally. So that's the case. But I agree with you. At the end of the day, well, if customers can encrypt the data using their own keys, why would Cloud Act even, then Cloud Act kind of loses some of its enforcements? Yes, it does. And that's why we haven't handed over data, because of that. But also, to be clear, Google consumer services, that is Gmail or the stuff that you use on a daily basis, that's a different story. That's a different story. For that, data can be handed out related to GDPR and to support crime fighting authorities and all of that. So I think so Cloud Act has a lot of leverage for open consumer services in different ways. But when it comes to enterprise services where we on the legal contracting with customers, for that Cloud Act is weaker. And to be honest, you know, how many crime investigation by FBI in the United States for a crime that happened on US soil would need data from Vansbro kommun? Honestly, I have such a hard time coming up with a scenario where that would be the case. But on the other hand, for Gmail, for WhatsApp, for Facebook chats, for, you know, there's a lot of those that, and that's a different discussion, I think. But for you know, for the enterprise storage of data in our platforms, I have such a hard time coming up with it. When Peltarion helps, you know, a Swedish authority to build a really good chatbot using AI and ML, why would FBI, under what circumstances would FBI want to have that data? You know, it's really far-fetched, I think. And that's why that's what makes me, and you can probably sense it, a bit frustrated, because we're painting ghosts in Cloud Act that doesn't exist. And unfortunately, most of those ghosts are painted by people who wants Cloud Act to be something that Cloud Act is not. So I think that's an important thing to point out. And also, while talking on encryption, the average data center in Sweden, be it in a private company or a municipality, data is not encrypted at all. Data is completely open, right? So I think that's also an interesting thing to reflect on. And how many hackers are inside your environment right now without you knowing, looking at your data? You know, that's the scary thing I also think people need to think about.
Yes, and then I wanted to ask Mikael, for example, your clients. I mean, some of them probably also go on the alternative to have the servers in Sweden or have their own servers, for example. So what would you say? Why would someone need to take that turn and do that decision? Are there specific clients, or why would you recommend them to not use cloud, for example?
Well, I think the primary question one should ask oneself is, I mean, what kind of information will I be storing? What kind of information will I put in the cloud? And what would the potential relevance for this information be to a US authority? I mean, as Ted mentioned, it's probably in most cases completely irrelevant, but I think you'll also have to do some kind of risk assessment around that and start with that before you proceed further.
And then Evelina, I wanted to ask you almost the same question. So you mentioned that already in the first discussions with your customers, there's kind of a split if they even want to start moving data. Do you have the same, or do your customers, have they done that processing beforehand, before they even reach out to you? Or are they kind of hesitant on, I guess it's not the most careful data or the sensitive data that they come with to you guys, or how does that work?
It can be. Sometimes they've done their homework, sometimes not. But I think it's always good to have the discussion and just see, so what are you afraid of? And as Mikael mentioned, what are the data? What do you want to do here? Also, just to make sure that there are no misunderstandings and misconceptions. Because, I mean, sometimes it is super sensitive data, and we can handle that. But just be sure of what you're doing. Yeah.
Okay, thanks. That's great. So we do have an interesting question from the audience here. So this is for all of you to answer. Do you know if any other country have a similar to Cloud Act, that would apply to US companies? And if so, how do US recommend that their own companies to deal with other countries' Cloud Act equivalents?
Yeah, I can answer parts of that. So Cloud Act, first of all, is bilateral. So it really gives any country the ability to sign an agreement with the United States to offer their crime-fighting authorities the same rights as the United States crime-fighting authorities. And the United Kingdom is the first one. They did so about a year ago. So they now have a bilateral agreement between the United States and the United Kingdom having the exact same rights. I think for Sweden could do the same, but I think we're probably waiting for the evidence initiative to take place. And to some extent, you have the MLATs. The MLATs have been around for 20 years, and there's a lot of MLATs between a lot of different countries right now, actually. So you have that same kind of thing.
Evelina or Mikael, do you have anything to add on to that, or?
No, I agree with Ted. I mean, I think we have had the EU-US mutual legal assistance treaty in place for quite some time. And I think a lot of requests are already based on that. So yeah.
Thank you. So we did have a question in the chat actually also. And I think it's mostly for you, Ted. Can you clarify why individual Google services like Gmail are much more of a problem from a Cloud Act perspective, at least compared to enterprise services?
So again, to be clear, if you have a Gmail as part of your enterprise contract with Google, which we call Google Workplace these days, formerly known as G Suite, then no, then we on the contract. But for as an example, consumer services that we have for Gmail, etc., is not as if we get a request for that, we will. It's similar to how it works with a private company, but with a private company, you have much more the ability for encryption using your encryption keys and things like that. So yeah, maybe I kind of described it in the wrong way. We haven't given out data for Gmail either, but for consumer services sharing, it was more the fact that I think those would be more appropriate for or in a position to get requests from US crime fighting authorities, if there is part of an investigation that they realize that there's a Swedish person having a Gmail account. And the thing is that if you have a Gmail account, a consumer Gmail account, Google does not guarantee you where that data is being stored. That data, we decide where that data is stored. It's a global distributed system. So your emails might be in the United States or in Australia or in Japan or in China. You have no control over that. So as such, you're not kind of protected in the same way, to be honest. When you have your enterprise agreement with Google, you decide where the data resides. Consumers cannot do that. So I think that's probably the biggest difference.
Thank you so much. And we just have a few minutes left, and just to give the audience a little takeaway, what would be your #1 tip for the risk assessment on if you decide to go on Cloud Act or having your own servers, for example? Can you name one thing that they need to remember?
Yeah, well, as I mentioned, I would absolutely start with thinking about what type of data are we talking about. That would be my starting point.
And make an overall assessment.
So what is the data? Make the overall and a big assessment where you weigh in all the different aspects of the risks. Ted, do you want to add on?
Yeah, I think I've talked enough, but I agree. And I think, it's so sad that you stop using this because there is a statement when probably 80-90% of the data you do have is unsensitive and would not even be even if the ESAM statement would be true, that's only valid for 10, 15, maybe 20% of your data, which is data that includes, sensitive information. So what about the rest? And that's what we're doing now with banks. We have, we are building really cool solutions with banks in Sweden today, where they say, well, these 25% of the data we will not touch for now, but all the other stuff we can do, right? So why wait when there's just a small portion that might be problematic? So that's my guidance. So classify your data and get started with something simple and see what happens. I know there's a healthcare region that started just a few weeks ago with using prescription for glasses. They built this small app in the cloud where people can go in and get prescription for their glasses and get healthcare money for it. And because they felt that it's so unsensitive, let's try it and see what happens. And that's the kind of spirit I would want to see.
Thank you so much. So now we had a bit of inspiration to at least dare to do the risk assessment and see what data you have and see if it's actually viable to go and see if cloud services would be something. I think this is a topic that will continue. And as you said, we're waiting for some governmental guidelines on this topic, for example, and case law to come. So we have a bit more clarity, as you were asking for, Evelina. So thank you very much for participating today. We really value these collaborations that we have with our partners to be able to share information and also inspiration to our other partners. So we would be happy to see you come join us for a webinar again. Thank you so much. Josephine, just say bye from both of us, and thank you so much. And please stay tuned for new episodes of the Data Factory series. And if you have any suggestions on topics that you would want to hear and discuss, please let us know.
Great. Thank you so much.
Thank you, all the panelists.